talking to you today about the unique challenges of product marketing in legal technology. The company I work for, Everlaw, serves attorneys at the moment of electronic discovery. And I'll get more into that in a second. Just a brief overview. That's me. I'm a product marketing manager for Everlaw. We're based in Oakland, California. We're a rapidly growing startup with 150 employees. I'm going to go over a brief overview of the e-discovery market. So for those of you who aren't familiar, you can gain a better understanding of the challenges that our company faces, specifically when we're marketing to lawyers. And my goal is that the lessons that I share with you today will also be applicable for any of you who are involved in B2B marketing or similar industries where you're marketing to busy professionals, such as healthcare, financial services, and any other related industries. I'll stop early for questions at the end as well. We're going to go over a brief overview of what lawyers are like as a demographic, and then three specific challenges of product marketing in the legal industry: creating engaging content for your buyer and customer personas, how to source case studies when your potential market is extremely busy and under a lot of pressure and doesn't really have spare time to do you a favor, and finally, how to bridge the gap in communication between product development and your prospects. Before I begin, raise your hand if you think lawyers are money-hungry scumbags. I don't care. I mean, I won't take it personally. I don't practice law, but also, who are you going to call when the shit hits the fan but a lawyer? So that's fine. Who thinks that lawyers are irritable and way too driven? It's okay. Nobody? Great. I want to set the record straight. Overall, in the legal industry, specifically within e-discovery, you have a need at any point in a case when it's going to trial to process a huge amount of information. The data set that we use in the legal industry as like a sample set for demonstrating to prospects is the Enron data set. And this is way back in the day, like 2004 or something like that. I honestly don't remember when the Enron litigation was. But you're dealing with millions of emails, company chats, depending on whatever the cause of action as well, text messages, product management files. And there's been a huge explosion in data that's involved in litigation. It's estimated that the global e-discovery market is about 17 billion. However, there's been a huge lag in technology, whereas only $1.5 billion has been invested in legal technology. And what's it's created is a giant market that is hungry for more sophisticated solutions that doesn't necessarily have them, but at the same time, doesn't also necessarily have the time to invest in technological aptitude or to really look around for a better solution because deadlines are so tight and there's such a huge volume of information to process for every legal cause of action. Where Everlaw enters into the picture is that we've developed modern technology that enables customers to ingest, search, and review the information at play in any legal matter, to unlock hidden data in that information through the use of powerful AI, and to act on what they discover by an integrated suite of case preparation tools. How do you convey that information to lawyers? The thing about lawyers is that, in fact, we're extremely hardworking, we're loyal to our clients, and very smart. The challenge of marketing to lawyers is that because they work so hard and they're extremely dedicated to their clients' interests, they don't have a whole lot of time to educate themselves on technology or related legal services. A great example could be a firm that's involved in Johnson & Johnson litigation. I don't know if you've heard of like talc powder and its carcinogenic effects, alleged carcinogenic effects. I don't know, it's not my place to take an opinion, but the lawyers involved in that matter are probably working 12 to 16-hour days just on the fact-finding aspects of that case alone. They're also extremely smart. This is not the space for gimmicky slogans, for product messaging that is not well thought out, for quick, easy one-off sales. These people went to intellectual boot camp. They can spot errors in logic from a mile away. And so whatever content you're creating has to be both engaging, but watertight. You can't have any mistakes. Another challenge in marketing to these professionals is that every area of legal practice is unique, and every case is unique. For those of you who are unfamiliar with legal, it's extremely different when I am a plaintiff side firm representing a group of plaintiffs in a class action lawsuit against Johnson & Johnson, to use my previous example, versus a small mom and pop personal injury firm where I'm representing people in hit and run collisions, versus a mergers and acquisitions firm or bankruptcy law. When you're developing collateral for this demographic and you want product stats, for example, it's not as if there are common search terms involved in e-discovery. Every matter is going to have different pieces of evidence that are relevant to that claim. Every field of law is going to have different workflows that they're going to need to use. Another challenge of marketing to lawyers is that customer personas are clear, but buyer personas are opaque. What I mean to say here is that it's very easy to segment the different roles within a law firm, all the way from contract reviewer attorney to a paralegal to an IT professional to a senior associate to a managing partner at a law firm. Anyone with any understanding of the practice of law knows that, for example, someone who just graduated law school maybe a year ago, just entered a law firm, is probably going to be doing a lot of individual document by document review. These are the people who, when they're reviewing the Enron data set, have to read through every single email, code the document for any issues that they might find, possibly escalate that to a review administrator. Paralegals are more involved in administering the course of e-discovery. They probably also are involved in preparing outlines for case discovery, whereas a managing partner is overseeing the litigation from kind of more of a post-discovery perspective, where they're getting ready for depositions or trial. They're taking the compilation of evidence along with the outlines that their paralegals have produced, and they're going into a face-to-face situation armed with the facts and their significance. That's all easy to segment out. But who's actually making the buying decision at every law firm is very idiosyncratic. And it takes a lot of per-account discovery to figure out who's signing off on the check to use e-discovery software. At one firm, it may be the IT professional who's in charge of choosing software for the attorneys and training people at their firm. At another firm, it might be the managing partners who are signing off. And each of these buyer personas requires distinct messaging. And there's no default buyer persona for each customer. Technological competence also varies widely among customer personas within the legal market, within the legal industry. A lot of this is due to a generational spread. Typically at a law firm, people who are at the partner or managing partner level have been in the profession for a long time. They have worked their way up to the top. They have worked their way up to the top through their knowledge of the practice of law and through their prowess at the practice of law, but they've not worked their way up to the top by necessarily staying up to date with the latest legal technology. In contrast, people who have joined the profession more recently tend to be more open to being early adopters of technology. And people who are fulfilling the role of paralegals and IT professionals tend to be more up to date with the latest technology because they're closer to the process of electronic discovery, that is, reviewing electronically stored information. Finally, one key thing to remember about the legal industry is that lawyers have a professional responsibility to protect their clients' information while also staying abreast of technology. I'll get into this later in the presentation, but it's kind of funny if you think about everything that I've said before about how these people are busy, how people who have worked their way up to the partner, senior partner, managing partner level don't necessarily have the direct need for a lot of technological competence. It's actually codified into the American Bar Association's model rules of professional conduct that lawyers shall stay abreast of technology precisely to protect their clients' interests. I'll get into this more later. Problem number one. I want you all to remember we've got a population of extremely intelligent, hardworking professionals, not a whole lot of time to spare. Mic that's falling off my ear. People where they have varying levels of technological capability, varying needs for technology. It's unclear who's buying what. At the same time, there's a very clear directive from their professional organization to stay abreast of technology. So the first problem that we face when marketing to legal professionals is how to create engaging content. I know everybody's organization is different, but at least at Everlaw, the PMM team has a very prominent role in content creation. And kind of like the prevailing thought is that white papers and like dense content is the way to go. And that's because attorneys are highly educated and deal with densely written information. Raise your hand if you've ever had to read or review a legal contract. Yeah, not fun times, right? They are written worse than the labyrinth of Crete. It's just like so many clauses upon different clauses, and your brain just kind of gets used to doing that when you're a lawyer. And that's why the industry standard does tend to heavily favor white papers and long-form content. The idea being that if I am a hypothetical software or product organization within the legal industry, if I can prove to lawyers that I know what I'm talking about, that I'm abreast of the latest developments in the law, different legal rules, that therefore they will take me seriously as a company because I know things. It seems logical. Writers within the legal industry as well are often recovering attorneys like myself. And so having been through that training for legal writing, there's a very natural inclination to write that way with clauses upon subclauses and sentences with several semicolons that read like paragraphs, and it all looks so beautiful, but it's actually not that fun to read. Previously, this white paper would have been an example of typical marketing content in the legal industry. This was kind of an older piece of marketing content. Put FRE 502 clawbacks into action with Everlaw. Wow. Wow, guys, this sounds so amazing. And, I've got to get this filing in by 2 p.m. today. Otherwise, my client is in hot water. But no, let's take an hour to read your white paper. Kind of a disconnect there. Previously, we had focused heavily on white paper creation, but in brainstorming how and why we were going to revamp our marketing, we decided to actually experiment with some shorter form content and with some video content. What we actually discovered was that by investing heavily in a program of webinar creation, we were able to attract more leads, more high-quality leads, with actually a smaller investment of time on our part. The amount of time that it creates in the legal marketing industry to build a deck and to come up with content and a program for a half-hour presentation is vastly smaller than what it takes to write a well-written white paper with correctly formatted legal citations. We started doing live and on-demand webinars in April of this year, and we found that it actually doubled the amount of leads that we were able to attract versus a white paper. And we also found that by hosting these webinars on demand and remarketing them to our email newsletter, that we're able to dramatically increase the quality and the quantity of our leads. This might seem obvious to some of you, but to some of us in the legal marketing industry, it wasn't obvious. We had just assumed that because our target market is in a profession where they have to consume a lot of written content all of the time and is required to stay abreast of the latest developments in the law, that by providing them content similar to what they have to consume for their day-to-day jobs, that would create authority and create interest. In fact, what we had failed to consider until we actually started experimenting was that because they're under a huge amount of time pressure, short form live content where they can ask questions in real time is way more appealing. The takeaway from here, for me at least, is that you have to experiment, constantly be experimenting, no matter what you think about your target market. And I even thought I was an expert too because I'm a lawyer. Couldn't have been more wrong about this. The next challenge we faced, raise your hand if you work in a field where you're marketing to professionals or B2B marketing, financial services, healthcare, yeah. I'm sure you are also dealing with people who are busy. Like lawyers have to get everything done yesterday and there is no spare time. So when I have a contact or a lead for a case study, either from our sales team or from our accounts team, I'm calling someone who's under a huge amount of demands, and I'm asking them to do me a favor, right? I'm asking them to donate a half hour to an hour of their time for an interview, and then more time after that to review a written case study, if not more for a video case study. The legal profession in particular also tends to be very risk adverse. One second, please. They tend to be very risk averse. There's a high duty of confidentiality towards their clients. They also don't necessarily want to disclose their pain points in a case study because it's effectively, in their minds, exposing their firm to criticism, potentially, or at least to unwelcome questions or not ideal questions from potential clients, right? If I'm a law firm trying to attract corporate business from, the Chevron Corporation, and there's a case study on how our software used to be clunky and out of date, Chevron might not consider me as serious a player as a different firm. There's also an issue with disclosing particular names, right? A law firm might not, because they're risk averse, want to disclose previous issues that they've faced. So how do you sell a case study to prospects? We had problems even getting people on the phone. We were always phrasing these requests in terms of, we'd love to tell your story. Would you be willing to get on the phone with us for an hour? And the response rate was pretty low. This was key to getting more case studies through our pipeline. I've cited this here. Within the ABA Model Rules of Professional Conduct, which most states have adopted as their guiding rules for lawyers' professional conduct, lawyers are required to stay abreast of changes in the law, including the benefits and risks associated with relevant technology. There's also another section in the ABA Model Rules of Professional Conduct where it states that lawyers are ethically obligated to use the best tools and technology available to further their clients' interests. So I basically decided, well, let's change our pitch for case studies to clients and see what happens. I started writing my emails to potential case study contacts in terms of the benefits to them of doing a case study, specifically referencing these rules. I sold the case studies to our clients in terms of a piece of marketing literature that they could use to attract more corporate business in terms of highlighting their commitment to staying abreast of the latest technology developments and their commitment to using the best technology to further their clients' interests, to discover truth faster, to speed up the process of review, and to control costs while improving accuracy. So I basically took these very clear directives from the professional organizations that govern how lawyers are supposed to work, tied it back into the ask, and sold it to them in terms of a piece of literature that's going to get them more business. And the response was huge. Our rate of yeses to requesting participation in case studies went through the roof. We were also able to build out more video case studies as a result, which was huge for our marketing department. But it's also extremely useful to our clients, too, to have a piece of marketing literature that they can then use when they're in the process of attracting new business for their firm. I also made sure to reassure them of their voice in the editorial process, to involve them very heavily in the process of content creation and editing from the beginning to the end. I'm hoping that the key takeaway for those of you who are involved in similar professions, where you're marketing to healthcare, financial services professionals, or other industries, is that if you can find any rules in their professional organizations that govern the use of technology and have a similar mandate to use the best tools available to serve others, that you could also adopt a similar strategy and experiment, see if it changes the amount of case studies that you're able to publish. Finally, another problem that we've tended to face in the legal industry is the gap between product development versus prospects' needs. If you remember earlier when I said that every matter in the legal industry is unique and every area of the practice of law is unique, what happens when you're developing software for the legal industry is that you have customers with such diverse pain points that solving one pain point for a particular practice of law or a particular cause of action may have a huge impact on those particular clients or customers, but zero impact on another. To give you an example, if I have a client that is involved in litigation against a public utility company, structural drawings of those components of the public utility, say power lines, are extremely important to that cause of action. So if my software can't view architectural CAD files, then that's terrible for that client. At Everlaw, we're lucky relative to our competitors in that we have a very fast release cycle. So our engineers can incorporate that feedback and then release improvements to our product every 4 weeks. For those clients or clients in related matters, that is huge news, and product and engineering will probably want us to make a big deal out of it. However, if our sales team is trying to court business from a mergers and acquisitions firm, they could give 2 cents about architectural CAD files. So the unique challenge for product marketing is how to communicate this in a way that both reflects its significance for a group of our target demographic that has an enormous pain point versus a demographic that could care less. Our solution to this, and again, this might seem basic for some of you, but to put this in context, until July of 2018, the marketing department at Everlaw was 1 person. I was actually part of a very new product marketing team at the company. What I did was basically just interface with product early on in the development cycle. It took a lot of patience internally to develop a framework for evaluating releases, for settling on appropriate messaging, and it also took a lot of delicacy with our product and engineering teams. Nobody wants to feel like the thing that they invested their heart and soul into over the last 4 weeks is a minor or unimportant feature. So we had to develop a framework for indicating the importance of a feature while also being sensitive to the fact that other people were working very hard on that feature, regardless of its wider impact on our prospects. It took a lot of education on our part as well to communicate to product and engineering that there's a very different way of talking about our product external to the company versus talking about our product to current customers who are using it day in and day out. It was a very big mind shift to go from talking about this is the button that does the thing, that pulls the blah, that does the XYZ, to here is a problem and this is how we can solve it. My only piece of advice, if you're in a similar industry or facing a similar challenge on your team, is that time, patience, and process are your best friends. That's it for now. We've got about 3 minutes left, and so if you have any questions for me, I'd love to hear them. Yes, in the back, they're coming back to you with the mic. Or you can just shout, I don't care. Yeah.
How did y'all market your webinars?
Right, so our webinars, we were lucky in that we had a large email database of current and prospective clients. We marketed them to both current and prospective clients because, the funny thing about our platform is that attorneys can either sign up for an annual subscription. We only bill on the basis of gigabytes stored on the platform. So unlimited users, unlimited uses of the software. You just pay for the gigabytes that you host. You can do an annual subscription or you can do a per case subscription, meaning that once the matter is closed, you don't have to pay us anymore. Your information goes off the servers. That means that one firm on a per case subscription may have other attorneys with other matters open that could also get onto our platform. So we just used our email database. We did publish some information about this on social, but we didn't get many leads via social. It was purely email-based marketing. In a couple of cases, we have done webinars with ACEDS, which is a professional association of e-discovery professionals. We also did some through ALM, which is a media conglomerate relevant to the legal industry. But both of those organizations only marketed the webinars via email to their prospects. That's just typical of the legal industry. Attorneys will tend to check their inbox much more frequently than they will look at social media for relevant professional news. They tend to go there for a distraction. Anyone else? Yes.
Here, I come with over.
Hi. Oh,
Hey.
I really don't like this. How did you bridge the difference between user personas and buyer personas? So we have the same issue at our company that we very much understand the different functions and what they do and their role.
Yeah.
So that's users,
Right.
we sometimes say. And we also understand who uses our actual tool. But how do you distinguish like user versus buyer personas and getting to the right person?
That's a great question. It's also a very difficult question. Like I said, it's highly idiosyncratic, and it really depends on a per firm basis. So what we've basically done is build out marketing collateral that speaks to the interest of each of these personas and just made it available to our sales team. Again, like it's not really a distinction that you can make in general because, like I said, at one firm, it's the IT department that's signing off on e-discovery software, and at another firm, it's a managing partner. So our solution was to just make different collateral for each persona available to the sales team. That's the most scalable. And we also try in our video case studies in particular to focus on a little bit of each buyer persona and to speak to the benefit of the firm as a whole. because we believe that everyone at a firm is interested in collaborating more efficiently. That's the one common thread that we've been able to find throughout our target market. We're actually a minute over, guys, so I'm going to wrap up right now. It's been a pleasure speaking to you all. If you have any questions or you want to stay in contact, my socials are up there. So thank you all for your attention.